Let's talk about Chapter 6, Multiple Representation and Customer Service Agreement. A multiple representation involves any situation where two or more clients are in a real estate transaction and they're represented by a single brokerage. So there can be situations where you have a single broker or a salesperson representing both buyers and sellers, or different broker or salesperson is employed by the same brokerage, same office or different offices representing both buyers and sellers. One or more brokers or salesperson employed by the same brokerage representing multiple buyers negotiating over the same property. A discussion of key issues surrounding multiple representation is necessary prior to discussing disclosure procedures and form preparation. The notion of a competing interest. The brokerage is in a fiduciary relationship must always act in the client's best interest. However, brokerage practicing multiple representation represents the interests of two or more parties, which is the buyer and the seller, that are invariably dramatically opposite. The buyer would like a lower sale price, the seller would always like higher sale price. Multiple representation places the brokerage in a difficult situation as competing interests of the buyers and the sellers of competing buyers cannot be simultaneously fulfilled, given the brokerage in a fiduciary relationship must always act in the best interest of the client, give undivided priority to the client, and obey the client's legal instruction. So, in case of imputed knowledge is knowledge or notice of facts known by one party that are deemed to be also be known by another. For real estate purpose, knowledge of a broker or a salesperson is deemed to be known to all other salesperson or brokers and employing brokerage. So multiple representation is inherent in various and commonly represented encounter situations within real estate brokerage. At the heart of the problem lies in the imputed knowledge. The representation agreement, be it with a buyer or a seller, effectively makes the brokerage and all brokers or sellers represent the client. The underlying legal assumption is that all representatives in the brokerage share each other confidences. Um, the knowledge of confidential matters is imputed to all other representatives. That is, the knowledge of confidential matters is basically imputed to all other representatives. Defining duties. The challenge with multiple representation as currently practiced lies in defining precise duties onto the brokerage onto the respective clients. As often said, the devil is in the details when they serve two masters. Dangers lurk as even even a minor advantage given one over the other can dramatically tip the negotiation scale. Critics argue that those practicing multiple representation attempt to define the general and fiduciary obligations in what is at best some murky details of a limited loyalty, obedience, and disclosure to address client divergent interests. Legal experts point out that limitations in one general and fiduciary obligation are at best an artificial line in the sand and with inevitable confrontation in the court. Impartiality and limited disclosure. The brokerage agrees to act impartially and equally protect the interests of both clients while agreeing to abide by the limited duty of disclosure. However, the ability to even-handed objective and impartial is hampered by inevitable risks given the inherent conflict of interests that exist. Limits to such disclosures are then set out with the understanding that identified items cannot be disclosed to either clients unless instructed in writing to do so by the respective clients. So the multiple representation clause in the agreement says that the seller understands and acknowledges that the listing brokerage must be impartial when representing the seller and the buyer and equally protect the interests of buyer and seller. The seller understands and acknowledges that when representing both seller and the buyer, the listing brokerage shall have a duty of full disclosure to both buyer and seller, including a requirement to disclose all factual information about the property known to the listing brokerage. However, the seller further understands and acknowledges that the listing brokerage shall not disclose that the seller will and may or will accept less than the listing price unless otherwise instructed in writing by the seller, that the buyer may or will pay more than the offered price unless otherwise instructed by the buyer. The motivation of a offer of or personal information about the seller or buyer unless otherwise instructed in writing by the party to which the information applies, or unless failure to disclose would constitute fraudulent, unlawful, and unethical practice. The price the buyer should offer or the price that the seller should accept, and the listing brokerage shall not disclose the buyer the terms of any other offer. However, it's understood that factual information, market information about the comparable properties, and information known to the listing brokerage concerning potential uses for the property will be disclosed to both buyers and sellers to assist them to come to their own conclusions. Regarding the practical issues, multiple representation typically after arises after a single representation arrangement has been established with either buyer or seller. The brokerage must first inform the client of the possibility. When this occurs, both clients must be informed of the fact that before entering into an agreement with the brokerage, obtaining their consent. In doing so, the salesperson must accurately convey the limitation being imposed and the ramification of such limitation from the client perspective. Multiple representation. What are the disclosures required? Multiple representation disclosures involve two steps. Each step is detailed in relation to the Robertson 2 and the applicable wordings taken from Working with Realtor or from 810, Listing Agreement 200, and Confirmation of Cooperation and Representation or Form 320. To illustrate how the representation is explained and disclosure is confirmed. Commentary includes multiple representation and other disclosures as both are intertwined in regulatory and in form wordings. The step 1 is a disclosure before agreement and step 2 is disclosure after agreement. So under step 1, disclosure before agreement, there is a statutory requirement. Registrant must meet minimum disclosure requirements as set out in the Code of Ethics to buyers and sellers prior to entering into an agreement in respect of trading in real estate. Registrant must disclose services that will be provided and alternatives available to potential clients or customers. Part of that disclosure includes the fact that multiple representation could occur in which the brokerage provides representation to more than one client or provides services to more than one customer. Working with realtors or Form 810 provides information on seller and buyer representation, multiple representation, and customer service in line with the Code of Ethics. An acknowledgement is provided confirming that the buyer or seller has read and understood the form. So ask the seller to read the form and sign the acknowledgement. Provide a copy to the seller and retain the copy for brokerage record. Ask the buyer at first point of substantial contact to read the form and sign the acknowledgement. Provide the copy to the buyer and retain the copy for brokerage records. Provide explanation as required. Working with realtor is highlighted given its wide use in the marketplace. However, individual brokerage may develop the alternate wordings. The disclosure before the offer. Now, disclosure. So the two steps were like disclosure before agreement and disclosure before the offer. Again, it has to meet the statutory requirements, explain wordings, and also the complete form 320. So before agreement we complete form 810 and form 200, and and step 2 is disclosure before offer we complete form 320. The disclosure before offer. The recipient cannot represent more than one party to a trade without the written consent of all the parties being represented. Informed consent must be obtained at the at the point that the registrant wants to represent more than one client in the real estate transaction. The Ontario Real Estate Association has developed a form that addresses such disclosures prior to offer presentation. Confirmation of cooperation and representation Form T20 highlights multiple representation disclosures as well as other representation and customer service options that this versatile form addresses. If the client refuses to grant such consent, the brokerage must address one or more of its clients to seek alternate representation with respect to the transaction. Statutory requirements, Section 16 and 17 of the Code of Ethics details the various further disclosure requirements which must be read in conjunction with Section 22 of the General Regulations. Regarding the form wordings, confirmation of cooperation and representation on T20 is designed to address various matters prior to an offer, including multiple representation, buyer brokerage, customer service agreement, and representation or commission issues involving a cooperating brokerage. The form is prepared and signed prior to representation of an offer. Signatories include the listing brokerage, the cooperating brokerage, buyer, and a seller. This ensures that all parties are clearly understand who is being represented by whom, and the commission payable to the cooperating brokerage. Space is provided for any additional comments as the need arises. Customer service. REBA 2002, as previously discussed, clearly distinguished between client and the customer. Customer is someone who has entered into some form of customer service agreement with the brokerage but is not represented by the brokerage. Customer, while not owe fiduciary duties, must be dealt with honesty and with integrity. Historically, agency law provided certain protection to customers by the way of duty of care. Agency law provides some protection. Recall that the duty of care owed to the client applies to everything that is done and ought to be done for the client. The duty owed to customers is limited to giving of information, responding to questions, and doing anything performing functions that the salesperson on the behalf of the brokerage has agreed to for the customer. Our regulatory requirements have expanded the scope of application to customer. Various code of ethics provisions apply to both clients and customers. For example, registrants owe both client and customers consent and competent service and must demonstrate reasonable knowledge, skill, and judgment and competence in offering opinions, meet various disclosure requirements, disclose material defects, ensure compliance with regulatory requirements concerning the conveying of offer, provide disclosure of competing offers, deliver copies of agreement, deposit, and document in accordance with the code requirements. Customer service agreement. General regulations refer to the agreement other than the representation agreement in which the brokerage provides service to the customer as distinct from the representation agreement with the client. Wordings may vary, but a service agreement typically states that the brokerage is representing the client and the buyer or seller is a customer. Confirms that no representation exists in relation to the customer and the regulatory and limited general obligations are owed, but no fiduciary obligations. Identify specific services that must be provided to the customer, provides for written consent by the customer. So, service agreement is an agreement in which the brokerage provides services to the customer as distinct from a representation agreement with the client. REBA 2002 compliance. Provisions in REBA 2002 regarding service agreements are intended to minimize potential problems by ensuring that registrant and customers are both clear about the nature of services being offered. Information before agreement. As with the representation agreement, Section 10 of the Code of Ethics provides the buyers or sellers with be informed regarding various matters at the earliest practicable opportunity. Minimum consent. The Code of Ethics sets out the minimum information that must be obtained in the service agreement between the brokerage and the buyer or seller, copies of agreement, customer service form. They're like there's ORI form 201, 310, and 545. And in addition, they're like common errors or problems that can occur. So be mindful of those. That's all for today. Thanks.